Hello students, Business Law, Unit 5, Information Technology Act and Environmental Protection Act. In today's class, we discuss Information Technology Act 2000 objectives, digital signature, electronic governance. We also discuss Environmental Protection Act 1986, scope and scheme of the Act, general powers of central government. First, let us discuss about the objectives of Information Technology Act 2000. The Indian Information Technology Act 2000 was enacted on 17th October 2000 in India. This is the first cyber law which is established to regulate the information technology. This act is formed based on the United Nations Commission on International Trade Law, which has an aim of providing equal legal treatment to the users of electronic communication in United States. The main purpose behind the introduction of Information Technology Act 2000 in India is to boost and encourage electronic commerce, electronic transactions, and other activities concerned with business, commerce, or trade. Information Technology Act 2000 helps the government to prevent the misuse arising through the use of electronic media. Objectives of Information Technology Act 2000. The main aim of this act is to provide legal recognition for transactions which are conducted in electronic format via electronic data interchange. The key objectives are to provide legal recognition to all e-commerce transactions, to encourage and facilitate e-governance, to encourage and facilitate e-commerce, to encourage the use of electronic storage of data and information as a eco-friendly alternative instead of paper-based storage. To make certain amendments in Indian Penal Code, Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, the Reserve Bank of India Act 1934, the IT Act was passed to bring change in the modern law of electronic commerce, which was adopted by the United Nations Commission on International Trade Law to manage national and international level cyber crimes, to provide legal sanction for transferring of funds, to facilitate government departments in electronic filing of documents. Now, let us discuss about the positive and negative aspects of Information Technology Act 2000. Positive features. Information Technology Act 2000 has outlined several cyber crimes. Before the implementation of the Indian cyber law, there was no redressal body for solving the issues, and Indians were unable to seek any legal remedy for such issues. Information Technology Act 2000 has changed the complete scenario by solving out the cyber crimes taking place in the society. Before the introduction of Information Technology Act 2000, email was not allowed to be used as a legal form of communication and not served as a legal evidence in the court of law. The Information Technology Act 2000 has changed the complete scenario by legally identifying and accepting the electronic format. Information Technology Act is in fact a latest form. The Information Technology Act 2000 has offered such a legal infrastructure that it helps in performing e-commerce in an easy manner by the corporates, which was otherwise not possible before the introduction of Indian cyber law, as there was no body to regulate all online commercial transactions. Information Technology Act 2000 has provided legal validity and sanction to digital signatures which are used by the corporates to carry out the transactions online. Nowadays, corporate sector companies are usually saving their information on their own computers besides maintaining a separate backup. If in case any company's data is being hacked, copied or destroyed, in such a case the company holds an opportunity to have a statutory remedy according to the Information Technology Act 2000. Negative aspects of Information Technology Act 2000. E-commerce basically relies on the domain names, but the Information Technology Act 2000 does not cover the issues of the domain names of electronic commerce. Information Technology Act even fails to address the rights and liabilities of the domain name holders. Information Technology Act 2000 usually results in jurisdiction issues. Information Technology Act 2000 has failed to solve the issue of e-commerce, such as monitoring and controlling the content and privacy issues. Information Technology Act 2000 ignores the issues pertaining to the intellectual property rights like trademarks, copyrights, or patents. Information Technology Act fails to include several types of internet crimes and cyber crimes, namely cyber theft, cyber defamation, cyber fraud, cyber harassment, illegal credit card numbers, etc. Information Technology Act 2000 does not provide any proper framework for the implementation of Indian cyber laws. The Information Technology Act does not cover negotiable instruments as it is not capable of controlling the electronic payment gateways. Let us discuss about the digital signature, role of digital signature. A digital signature is one of the methods of encryption used to provide authentication. The main idea of the digital signature is to protect the message or data from modifications. Digital signature is very popular in the world of network security. Basically, it is a kind of asymmetric cryptography used to support the security properties of a handwritten signature on paper. The digital signature scheme provides two algorithms. One algorithm is for signing, which requires the user's secret or private key, and the other algorithm is for verifying signatures, which require the user's public key. The result of the signature process is called the digital signature. Role of digital signatures. Digital signatures are used to provide authentication of any electronic information. Consider two users, A and B. A wants to send a draft of a contract which is confidential to B, who is in some other city. Now A ensures B that the message is unchanged and is sent by him only. The sender A writes his draft of a contract into an email and applies a special function known as function on the message. This creates the checksum of the information. AI uses its private key and encrypts this checksum by applying its private key obtained from public private key authority. The encrypted message becomes A's digital signature of the message. The checksum and the message is then sent to the receiver B. At the other end, the receiver B receives the message and the checksum in order to make sure that message is undamaged from sender A. The receiver B applies the same hash function on the received message. This produces a checksum. It also uses A's public key to decrypt the checksum it received with the message. The two checksums are then compared. If they are matching, then the received message is undamaged and signature is valid one. Otherwise, the message is changed and signature is invalid. Electronic governance. Electronic governance refers to the process of filing and submission of any form or application or any other document with government department in the electronic format. Example: submission of the passport form online, filing of income tax returns online. For instance, there are Mi Seva Kendras in Telangana, which facilitate the public in paying their bills and apply for other government services online. The main benefit of e-governance is that it is less costly, quick, effective, efficient in nature. It also ensures accuracy in the performance of transactions. Rules relating to e-governance. All the rules relating to e-governance are enclosed in the Information Technology Act. The Act provides the legal recognition of digital signatures. Any signed document which is stored in electronic format would be considered as a valid and authenticated electronic record. Example of digital documents include e-filing of income tax returns, e-filing of patents or copyrights application, etc. According to Section 4 of the Information Technology Act, a document is considered as an e-document when it meets the conditions. When the document is present in the electronic format as an electronic record, when the document is used for future reference. Section 5 of the Act deals with the legal recognition of digital signatures. Any e-document bearing the signature of a person would be considered as a valid digital signature. As per Section 5, signature includes the handwritten sign or any other valid mark or stamp on the e-document. In the present day electronic world, e-governance has become an integral part of day-to-day life. Now, let us discuss the different dimensions of e-governance. As its name suggests, the model of e-governance will connect the citizens of a country to their government. It employs various democratic and public services. The government can contact their citizens and can listen to their suggestions, thereby improving the society. The model carries some services: e-citizen, e-transport, e-education, e-medicine, e-registration. Government to citizen. This will provide integrated service centers, e-citizen, which offer many services to citizens at one place. For example, certificates, ration card, payment of bills, taxes, submission of passport application. The Mi Seva is an example of one such center which is in Telangana state. E-transport. These centers will provide road transport authority related services including registration of motor vehicles, issue of driving license, tax and fee collection, etc. E-education. These centers will provide educational services to the citizens. E-medicine. Hospitals of different states are linked to provide a collaborative and improved medical service. E-registration. It provides services for registration of property, transfer of property, payment of tax, duty, etc. Consumer to government. This model deals with interaction of citizens with government. Applications like electronic voting, census work, tax payment all come under consumer to government. Government to business. Industries, business or enterprises are chief sources of income to a country. Example, when paying taxes, fees, getting licenses, etc. A service named e-taxation will provide a business with all these models. In order to develop government to business services, government must implement standards, provide secure payment mechanisms, public key infrastructure for performing secure and authentic transactions. Government to NGO. This model of e-governance aims at building connections between government and non-government organizations which help in the betterment of the society. It can be achieved through interaction and publication. That is, citizens and NGOs should be allowed to involve in government activities through publication and interaction. Government to government. This model aims at developing and improving government process. It is also known as e-administration. This model involves linking of all government offices into a network. They can carry out administrative jobs easily. The most important areas in this model are e-secretariat, e-police, e-court. E-secretariat aims at linking various government departments such as there can be the efficient exchange of information among them. E-police aims at keep tracking of both police personnel and criminals. The personal database will store records of police officers, their previous posting, specialization. This information will help in intelligent postings and promotion of police officials. The e-police service also includes online FIR filing, finding case status, etc. E-courts. This area aims at transforming the manual legal system to an automated system. The judges of higher courts like Supreme Court and High Court can consider appeal from a remote location using the intranet. The judges can give the decisions online based on the recorded facts of the case. Environmental Protection Act 1986. Objectives. Environmental Protection Act 1986. The Environmental Protection Act was enacted by the Indian Parliament during the 37th year of Republic India. On 23rd May 1986, President of India gave the approval for establishment, and on 19th November 1986, it came into existence. Environmental Protection Act 1986 is a set of comprehensive legislation for protecting Indian environment. It consists of 26 sections which are distributed in 4 different chapters. Environmental Protection Act 1986 is applicable to all the states of India for protecting and improving Indian environment from hazards to human beings, animals, plants and property. Environmental Protection Act 1986 is one of the most important acts laid down by the Indian Constitution. Objectives of Environment Protection Act 1986: to provide protection and improve the quality of environment, to empower the central government to adopt suitable measures, to prohibit the setting up of industrial facilities that harm the environment, to penalize those who endanger human environment safety and health, to prevent the occurrence of hazards to life on earth, to execute the resolution passed at the United Nations Conference on Human Environment held at Stockholm, Sweden in June 1972, to ensure coordination between regulatory agencies for environmental protection. Definitions given under Environmental Protection Act 1986. Environment. According to the Section 2A of Environmental Protection Act 1986, environment includes water, air and land and the interrelationship which exists among them, other water, land, air, human beings, other living creatures such as plants, microorganisms and property. Environmental pollutant. According to the Section 2B of the Act, environmental pollutant means any solid, liquid or gaseous substance present in such concentrations as may be or tend to be injurious to environment. Environmental pollution. According to Section 2C of the Act, environmental pollution means the presence in the environment of any environmental pollutant. Hazardous substance. According to Section 2E of the Act, hazardous substance means any substance or preparation which by reason of its chemical or physiochemical properties is likely to cause harm to human beings, other living creatures, plants, microorganisms, property or the environment. Occupier. According to Section 2F of the Act, occupier in relation to any factory or premises means a person who has control over the affairs of the factory or premises and includes the relation to any substance, the person in possession of the substance. Scope and scheme of the Act. The scope of Environmental Protection Act 86 is wide and covers all states of India. It is applicable for all types of aspects or factors related to technical, economical, environment. Points summarized. The scope of Environmental Protection Act 1986. It covers the pollution factors related to land, water, air. Its potential scope is broader with the term environment, which is defined to include water, air and land and the interrelationship which exists between these factors and human beings and also other living creatures like plants, animals, microorganisms and property. Its scope fixes responsibilities on persons who are carrying industrial operations or handling hazardous substances for prevention, control and abatement of environmental pollution. It empowers central government for taking corrective measures in order to protect the environment. Schemes of Environmental Protection Act 1986. Chapter 1 Preliminary. Preliminary is the first chapter of Environmental Protection Act 1986, which deals with the short title, extent, commencement, definitions of certain terms under the Act. Such terms may include environment, environmental pollutant, environmental pollution, handling, hazardous substances, and occupier. Chapter 2 General Powers of the Central Government. Chapter 2 deals with the general powers of the central government. By using these powers, central government can take corrective measures in order to improve and protect environment from various hazardous activities. It also has the power to impose penalties on various offences. Chapter 3 Prevention, Control and Abatement of Environmental Pollution. Chapter 3 of Environmental Protection Act 1986 deals with the activities related to the prevention, control and abatement of environmental pollution. Under this chapter, various conditions are established for restricting pollutant of environment. Chapter 4 Miscellaneous. Chapter 4 of Environmental Protection Act 1986 with the various miscellaneous conditions related to environmental pollution. It explains the conditions in following headings: protection of action taken in good faith, cognizance of offence, information, reports, returns, bar of jurisdiction, power of central government to delegate, power of central government to make rules. Prevention, control and abatement of environmental pollution. According to Section 7 of the Act, no person carrying on any industry, operation or process shall discharge or emit or permit to be discharged or emitted any environmental pollutants in excess of such standards as may be prescribed. According to Section 8 of the Act, no person shall handle or cause to be handled any hazardous substance except in accordance with such procedures and after complying with such safeguards as may be prescribed. In a simpler sense, everyone should follow the stringent emission or discharge standards as laid down in the Environmental Protection Act 1986. According to Section 9 of the Act, where the discharge of any environmental pollutant in excess of the prescribed standard occurs or is apprehended to occur due to any accident or event, the person responsible for such discharge and the person in charge of the place at which the discharge occurs shall be bound to prevent or mitigate the environmental pollution caused as a result of such discharge and shall also forthwith intimate the fact of such occurrence or apprehension of such occurrence, be bound, if called upon, to render all assistance to such authorities or agencies as may be prescribed. According to this section, anyone responsible for the discharge of pollutant in excess of the discharge standard is liable to take adequate measures to mitigate the environmental pollution. The authorities or agencies may be informed about the exigency so that the remedial measures may be taken to prevent it. Further, the concerned person is liable to bear the expenses incurred in preventing the pollution. Offences and penalties. Section 15 of the Act provides for the penalty of contravention of the provisions of the Act and the rules, orders, and directions. According to Section 15(1) of the Act, whoever fails to comply with or contravenes any of the provisions of this Act or the rules made or orders or directions issued thereunder shall, in respect of each such failure or contravention, be punishable with imprisonment for a term which may extend to 5 years, with fine which may extend to 1 lakh rupees, or with both, and in case the failure or contravention continues, with additional fine which may extend to 5,000 rupees for every day during which such failure or contravention continues after the conviction for the first such failure or contravention. This section simply means that those not complying with the standard conditions are found violating the Act or penalized with imprisonment for a specific period or with a fine of rupees 1 lakh or with both. Serious violations of law can lead to stiffer penalties of 7 years of imprisonment and fine of rupees 5,000 per day. Similarly, any such offence committed by a company or any department of government, then the concerned individuals are liable for punishment as laid down in the Act. The public concern and support is essential to accomplish the Environment Protection Act. It needs the encouragement by environmentalists, social activists, policymakers, environmental philosophers, politicians, bureaucrats, industrialists for the effective implementation of environmental laws for the conservation and protection of the environment. Thank you.